That's it. 27. Alpha. Eh? Like, me where they get. Wait, thousand. You will make me stand. I get test.
Good morning, class. How you can hear me loud and clear?
Yes, sir, we can.
Okay. Before we set the modalities for test, I just want to. Good morning, class. How you can hear me loud and clear?
Yes, sir, we can.
Okay, just give me 1 minute. Let me exit from the YouTube before we set so that the audio will not affect our discussion. Good morning, class. How Okay, I'm back now. Yes. Now I'm sure you are aware that today is our test. I could hear some voices saying that I'm at the gate. I want to go for the test. So are we ready for the test? Class?
Yes, sir.
Oh, okay. Then, yeah, before I go on, I want to confirm from the class rep. Did you have your tutorial yesterday with Professor Dikile?
Yes, sir, we did.
Okay, and how was the engagement? How we now understand better how to answer law questions?
Yes, sir.
Okay, so because I'm surprised I saw some opinion poll about the issues that students normally face with in faculty of law, and there's some of them cited the law of thought as having difficulties in raising issues, and I'm surprised that for those that did law of thought last year, they shouldn't be complaining about how to raise issues from the scenario given to you, because we did extensively on that. I was in class physically with Professor Adikile to take them through some past questions, and we raised vital issues on how to answer law questions generally. So when I saw the opinion poll, I was like, maybe majorly those that complained about how to raise issues were those that were not in class or were not active enough
You just
in
kind of
class.
saying that like this is around me.
I want to believe that your class will ensure that you follow the details of the engagement you had with Professor Adikile. So, and once we are done with our lectures as well, I will also create time to take you through some tips on how to answer the questions and how to do well in general in the exam. So now, having said that, I want to save the bit for the last, which is the test that you felt prepared for. Now, I want to do a bit of background on the thought of occupiers liability, and from next week we're going to start the topic fully. And to start a note of warning that please, when you are reading this topic, because it's also wide, it's also very wide, but not as wide as negligence. And for those that are understood fully the concept of negligence, I'm sure you should find this topic very interesting, because the vital principles of this particular thought also resonates well with the thought of negligence. So if you understand the thought of negligence fully, I believe that the understanding occupiers liability will not be an issue. Akiyemi, your hand is up all is well.
So, sorry, sir. Sir, can we do the test before class? Because our head, so that we
What
don't
say?
forget. So, sir, can we do test before the class so that we don't forget all this thing I've read?
Do you determine how a pilot of a plane will direct his plane? I'm asking Akiyemi, I'm asking you, do you have a right to determine when a test will be conducted, and when or when the plane will move and when the plane will not move?
No, sir.
Please, stop that illegal request, please. So, as I was saying before that interruption, don't forget that we're on live, and do not let the world see your demeanor as representing the entire class demeanor. Please, that's not good at all. That's not good at all. Okay, so as I was saying before the interruption, I said that with the understanding of a thought of negligence, you should not you should not have any issue at all with understanding occupiers liability. And I said the principles, most of the principles that have resonated well with you under negligence, you'll find some of these principles also in occupiers liability. So, having said that, the discussion fully will start on Monday next week on the thought of on the vacancy liability, so on occupiers liability that I'm talking about. Now, let's look at the background to this topic. But before I go on, can someone within 1 minute or 2 minutes tell me the take home from the thought of negligence? The take home from the thought of negligence. What did you understand in summary by the thought of negligence? Because that's sort of where my discussion will start on the occupiers liability today. Paul, are you in this class? Paul. Is Paul in this class? You remember I had the meeting last Sunday, and I said I'm going to call you out to answer my question in class. Paul, are you in this class? Hello?
Sir, maybe he's in the YouTube.
Okay. All right. Then that's Amanda. Amanda, you just answered me now.
Yes, sir.
Yes. Can you give us the takeaway from your discussions on a thought of negligence? I'm waiting. You. Amanda suddenly disappeared.
I think so for negligence,
Please try and turn on your video. Try and turn on your video when you are asking my question.
I'm sorry, please. I'm just trying to do my video. It's not connecting.
But so, if you want to write your test, how do you write the test without the video on? Oh, okay.
Seems like Amanda is not.
Okay. Okay, Elizabeth, can you help us?
Okay, sir. So
Thank you.
I think the thought of negligence is premised on modalities on our relationship with our neighbors, which
I can't see you as well. Though. I can't see you as well.
let me switch on my video.
I don't know. I don't want to be talking to AI or ChatGPT products.
In the middle. Okay.
Yes.
All right, sir. So I think the thought of negligence is premised on our relationship with our neighbors, and it buttresses on the duty of care, who we owe a duty of care, how to relate with them, and
I still can't see you. But
I can see myself.
no, class. Can you see her?
Yes.
Yes.
I see her.
We can
Yes,
see
sir.
her, sir.
Yes, sir.
We can.
Yes, sir.
Okay, go on then. Go on. If they can see you, no problem.
Okay, sir. So I said it's premised on the relationship with our neighbors, identifying who our neighbor is, which is those people that our acts can reasonably affect. And as such, we owe them some responsibilities, which is the duty of care. And then for every thought of negligence, for you to establish that a thought of negligence was, committed towards you, you must be able to establish that such neighbor owes you a duty of care. That duty of care has been breached, and as a result of the breach of duty of care, you have suffered some damages.
Okay. Brilliant. Thanks for the that insight. Now, it has given us the background of what will now dovetail in our discussion today. Now, what I'm particular about is the issue of your neighbor that you talk about. Now, and you have been duly informed of who your neighbor is. So I don't need to dwell so much on that. Now, having said that, for over a century, the law has recognized that people who occupy land, in particular, including buildings on land and all the appurtenances, have a duty towards the safety of others, toward the safety of others who come onto the land. Now, this duty developed through the common law, through the common law principles, and in 1957, for instance, it began to be regulated by statutes. So, of course, you know what common law is all about, and you know the intervention of statutes to either retain some of the principles of common law or entirely do a overhaul of the common law principle. Now, in 1957, these common law principles of the duty of care towards the safety of others who come to your land began to be regulated by statutes with the introduction of what we call Occupiers Liability Act. I'm sure some of you have read through this topic before coming to class today. And so there was Occupiers Liability Act of 1957, which regulated this duty. Now, this duty laid down rules about the duty of occupiers towards people who come onto their land with permission. So the emphasis is with permission. Now, after the 1957 Act, of course, there was also Occupiers Liability Act of 1984 in England. So which also set out the duty owed by occupiers towards those who enter their land without permission. Don't forget that I said the Occupiers Liability Act of 1957 regulated the occupiers on their duties to persons who come on their land with permission. Now, in UK, by 1984, they had another Occupiers Liability Act, which regulated the duty of the occupiers on those that come on their land, even without permission. So, if we say without permission, we mean the trespassers, those that came to the land as trespassers. Now, so the main duty of care, of the duty of occupiers of land, is now contained in various statutes. Okay, so in Nigeria, for example, since our history is traceable to the England based on our colonial history, so our own law is patterned after the British, the English law, okay, of 1957. So we are going to be looking at cases that have been decided over the years to drive home our points. Then although subjects remain undeveloped in Nigeria, but the there are statutes governing corporate liability in Nigeria, both in Lagos and other jurisdictions. But majorly, we are going to concern ourselves with the law in Lagos, and reference can also be made to other states as we go on. Now, before sharing my slide, because I'm just trying to give a background of what we are doing today. There's need for us to understand who is an occupier, who is a lawful visitor, who is a trespasser. Okay, then we look at the obligations on the part of occupiers towards lawful visitors, towards the trespasser, as the case may be. So, but essentially, can you see my screen now?
No, sir.
No, sir.
No, sir.
How about now?
Yeah, we're seeing it.
Yes, sir. Yes, sir.
Yes,
Okay.
sir, we're seeing it now.
Yes. So now, essentially, what we need to have at the back of our mind before I run through the slide a bit is that I call it the key point is that the law has long taken the view that the occupation of land gives rise to positive duties of care to protect the interests of other people who might be affected by hazards arising on that land. So, and I said this was developed through the common law and later regulated by the Occupiers Liability Act of 1984, but we'll not concern ourselves with 1984 because Nigeria had become independent since 1960. I just put it so that when you read on your own, you can also look at the Occupiers Liability Act of 1984. UK want to see what you can take from it. But essentially, we're looking at the Occupiers Liability Act of 1957 as a precursor to our own Occupiers Liability Acts, okay, of Occupiers Liability laws of respective states in Nigeria. Now, so one who has control of premises ought to ensure the safety of all persons entering the land. And so what the background Elizabeth gave us is a pointer drawn from the Lord Atkins principle of the proximity and entrant as the neighbors of the occupier. So, of course, you know the principle of the neighborhood as provided by Lord Atkins. So, read that principle very well. Is it very relevant to our discussion? Now, I start with the beginning of the slide. Also, look at this. Yes. Now, the justification of liability in occupiers liability. Class, can you see my screen? Or am I audible? How am I audible?
Yes, sir, we
Yes,
can see
sir.
you.
Okay. Now, so the justification of liability in occupiers liability is that it is a round of liability because it gives some control over and knowledge of the state of the premises. And it's natural and right that the occupier should have some degree of responsibility for the safety of persons entering his premises, which is permission. Underline it, which is permission. Now, in the language of the well-known passage in Lord Atkins' speech in Donegal and Stevenson, there is the possibility between the occupier and such persons, and there is neighbors under the common law. The essential element in determining who an occupier is occupation and control. So, just like we said under trespass to land, ownership of the said premises is not necessary. So, this is the justification, and this very brilliant class, I want to always do something before you set out to discuss any topic in the exam. Look at the basis of a particular of a particular subject matter. Justification will always guide you. I give I give a pointer to students that they should understand the element of a particular tort and also justification of the liability in that particular tort. Now, if I'm an occupier of a property and someone come onto my land and the person is injured, what is my business with that if the person does not take adequate care of himself? That is on normally. What is my justification? What is my liability on that? Now, the justification has been opined by several writers and also particularly from the extraction of the case of Stevenson, is that it is a rank of liability because it gives same control over and knowledge of the state of the premises. It is the occupier that knows the state of his premises. A visitor does not know the state of the premises of the occupier. Also, if a trespasser does not also know the state of the premises of the occupier. So on that note, since he knows so much about his own occupation, it is natural and right that the occupier should have some degree of responsibility for the safety of persons entering his premises with his permission. Now, we are going to see as we go on the liability of occupier even towards the so-called trespassers. Okay, so now having said that, let's now look at the learning outcomes of this topic. Now, don't forget that this is a working in progress slide. So I'm going to make it available to you as usual when I'm done. Now, at the end of this class, we are to understand properly, of course, occupiers' liability as a tort, nature and scope of liability, introducing the elements of the tort of occupiers' liability, statute-based liability, trespassers and the common duty of humanity, liability for the act of an independent contractor, defenses and remedies. Okay, so this is an outline for this particular topic. Now, let's look at the learning outcomes in specific. Now, I said overview that in this presentation, we shall be looking at the occupiers' liability, its nature and scope of liability, introducing the element of tort of the occupiers' liability. Presentation shall also look at statute-based liability, causes of trespasser, and the common duty of humanity, liability of act of an independent contractor, defenses and remedies, among others. Now, so these are my own learning outcome, which I believe will guide you when you are reading many textbooks on this area of law or on this area of thought principle. Now, at the end of the discussion, you should be able to do the following: know who is an occupier, and extent of its liability to the lawful visitors and also trespassers. So understand the basic element of occupiers' liability. Understand this what sort of dangers can be said to have arisen on a particular set of premises because of the state of the premises. Then understand when an occupier will owe someone a duty of care to protect that person from a danger arising because of the state of the premises under the Occupiers Liability Act and other like statutes. Then you should be able to identify various examples of premises, situations of occupation. Then finally, you should be able to discuss various defenses and remedies of occupiers' liability. I hope these learning outcomes are explicit enough. Class, I hope they are explicit enough.
Yes, sir.
Okay. So now, let's look at. Okay, I've already discussed the key points, the base of liability in this thought. Now, what comes to your mind, or what should run through your mind when reading also this particular topic, is that ask yourself whether the defendant had a sufficient degree of control over the premises to put them under a duty to a visitor. Okay, so this should always guide your your thoughts. You ask yourself whether the defendants had a sufficient degree of control over the premises to put them under a duty to a visitor. Now, this question is fundamental because where you do not have control over a particular occupation, okay, then you do not have, as well, you do not have, you don't owe duty to anyone coming over that particular land. So, in answering this question, or in justifying, or in putting into perspective the answer to this question, you may need to ask yourself who are in effective control of that particular premises. Now, before we go into this, there's also need for you to understand some concepts within this topic, and that has to do with occupier. I've been talking about occupier since. Now, I've not discussed or defined who is an occupier. I've also not defined who is a lawful visitor. I've also not defined who is a trespasser. Now, if you're able to clarify these concepts, then that will give you sufficient understanding of when a duty will be owed to a visitor, where a duty will be owed to a trespasser. Then who can we hold liable for injury or for damage or caused to a visitor or a trespasser? So we need to understand who an occupier is before we can hold him liable for whatever injury that might have been caused due to the state of his premises. Now, and I said that no statutory definition has been preferred on who an occupier is. Okay, I've not seen a statute that defines who an occupier is. Okay, but a cumulative understanding of every statute will give you a pointer that an occupier is someone who have a degree of control over a particular property. Now, so I said no statutory definition, but simply common law gives a clue. And by common law definition, say he is a person who will be treated as such under common law. Now, under common law, an occupier is the person who controls the premises. So they do not have to be the physical occupier nor the owner. So the critical issue is whether they exercise a sufficient degree of control to allow or prevent other people entry. So in this case, whether this level of control is exercised will be a question of fact. So it is a question of fact that will determine whether a person is an occupier or has a control over a particular premises at a particular period of time. If you read the case of Iris and Buckingham Corporation very well, and Wheat and Il Lacon Company Limited, these cases explain adequately the degree of control that is expected from the occupier before it can be held liable for the breach of the duty as expected under the tort of occupier's liability. So we're going to look at those cases next Monday. Now, that is for occupier. I'm just going back to that as we go on. Then you also have a lawful visitors. Now, who is a lawful visitor? Now, the question as to who is a lawful visitor is also a question of fact, depending on the circumstance of the case. Okay. So now the word visitor as used. Also, the statute does not define who a visitor is. Okay, but essentially, A visitor is someone that asks the permission of the occupier to visit his premises, whether implied permission or express permission. Now, however, persons entering premises as of right are lawful visitors. Okay, so whether you give someone express permission or not, where someone enters your premises as of right, the person is a lawful visitor. And a good example of this instance is the officers who enforces the law, or the officers who enforce the law, the officers who are saddled with the responsibility of keeping the peace in the society. And I give a good example that, for example, in Section 676 of the NEPA Act provides for this category of persons that are called visitors visitors as of rights to a premises. Now, the said provision entitles or allow the NEPA officials to enter premises with the hope of whether they want to inspect the meters or they want to carry out some allied matters in respect of their scope of operation. And so, I submit that the provision of Section 6 of the Act is wide enough to include also the police officers, okay, entry to such premises, who or without warrant, also firefighters, as well as public utility workers. So these persons, they are your visitors as of right. And you now understand why you need to keep these people to ensure the safety of these people when they are on your land. Now, so does the NEPA Act, for example, give the authority and persons acting on its behalf to enter premises for certain purpose, like reading the meter, of course, sufficient notice of intention to that effect, but are given to the occupier of that particular premises. Now, so the extent of the duty owed by the occupier to lawful visitors is the common duty of care, which has been explained under the thought of negligence. That is the common duty of care. So now the occupier ought to take such care in the circumstances of the case as reasonable to see to the safety of the visitor in using the premises for purpose for which he is invited or permitted by the occupier to be there. So, and please note this, that persons exercising the private rights of way are not visitors. So if I be given right of way, you are not visitor for this purpose. Now, and so you are not covered by the Act, by the NEPA Act. Then also persons exercising a public right of way are also not visitor. But as I'm going to see as we go on, in the case of Lorry and Walker, boating and stone, which you're already familiar with, you will see that the law also say that, or the court has already heard that a person with an implied a person with an implied permission, not person, a person with an implied permission, okay, is a lawful visitor. Now, the question I want to, what we now ask is that, who is the person with an implied permission? Who is the person with an implied permission? Now, where someone has been using your walkway or your apartment as a shortcut to reach its destination, and you tolerated that for years without complaining, the person is a visitor as contemplated by these thoughts. Now, you see the case of Lorry and Walker for that purpose. Now, in this case, the defendants are taking no serious steps to prevent persons who are using his own walkway. Okay, and the court heard that they are visitors for this purpose. So we are going to look at all those cases as we go on. Then, of course, you look at the case of boating and stove as well, where the court was to consider whether the building of a 7 feet wall was enough precaution against ball escapes to determine whether there has been a breach of duty of care by the occupier. You know that case very well. So, and it's not what you did in your under your trespass case as well. So now, aside from lawful visitors, who is a trespasser? Now, a trespasser also has not been fully defined by any act, but by the authority of courts over the years. You find that the court has defined who a trespasser is. For example, Lord Dundee, in the case of Addy and Sons versus Dumbrick, says that a person who goes on land without invitation of any sort and whose presence is either unknown to the proprietor or, if known, is practically objected to, is a trespasser. So that means where your presence is not welcome, you become a trespasser. Now, and trespass, of course, as we did under the trespass to land, you have been informed that trespass can be committed in various ways. It could be by entering upon the land in the possession of another, or it can be by remaining upon such land or placing material objects therein, and in every case without a justification. That was what we said when we were discussing the trespass to land. So, and it is immaterial that the alleged trespasser does not know that he is trespassing or that he intentionally or unintentionally encroached into land in possession of another. We have discussed all these things fully under trespass to land. Now, when the defendant enters land involuntarily by the act of force of another, I also told you the implication of that, where the defendant enters the land involuntarily by the act of force, by the act of force of another. The trespass is that of the person carrying in. So that's also as we were discussed in our trespass to land lecture. Now, there are instances whereby the irony of this thought is that there are instances whereby a lawful visitor can also turn to a trespasser. Class, can you give me a good example where a trespasser, a lawful visitor can also turn a trespasser?
Trespass ab initio.
Where permission is revoked.
Thank you. That is where permission is revoked. So, can you give me the case that directly come to mind?
Six carpenters case.
Balogun Alakija.
Thank you.
Balogun Alakija.
Thank you.
Alakija.
Yes, thank you. So, at this stage, because you have answered my question very well, let me just say this before we go on. I could see what I call the phobia in some of the class. Okay. I could see the phobia in many of you. Can I see some of your video on, so that let me give you a teaser before we go on. Thank you. Please let me see your video on, and I also turn on my video. Yes. Okay, good. I can see some faces that are frown. Some are looking unhappy. Some are also looking so dazed. Some are looking so so unconcerned with what we are doing this morning. Then some are looking also a bit indifferent. That let this man say what he want to say and give what it is, and let us go our own way. So I want to believe that represents the way I interpreted your faces. Now, if indeed it's portrayed the way I represented your faces. On that note, I want to say that relax, there will not be test today. Okay, so there won't be test today, so you can focus, you can concentrate on the class.
Wow.
Thank you. Thank you, sir.
Wow.
You see,
Wow.
they're not talking. You know, you take
Wow.
Thank you,
Very
sir.
good, sir.
Thank you.
Please don't read the text now,
Wow.
please.
Thank you so much.
You are the best.
This is the test hole.
You are just the best. You are just the best. I can confirm that.
Can you see now? Can you see? Can you see?
Sir, please don't read the text.
Abisola, you know that has kept quiet since morning. It's
When is the test?
Suddenly regain her voice. She suddenly regain her voice and start saying when will the test hold? When will the test hold? So what I can show you so that we can concentrate on the lecture today, because this lecture is very important to me, is that Grace, are you there, Grace? Can you turn on your camera, Grace? Grace, Unachi. Yes, aha.
I'm here, sir.
Yeah, okay. So when you heard the news that the test will not hold today, how do you feel? On top of the world, or indifferent?
Sir, I want to, I don't know, sir. I don't know how I felt.
Okay. So what I can.
So I was already crying. My laptop is about to die.
Imagine. So what I'm going to do is that I'm still consulting with my senior colleagues on this course to see how we can do a test that will be mutually beneficial to all of you. So I've got some experience from some feelers from some of your classmates about family law, and I don't want to go into that, but just to mention that you have a better arrangement than that one, and so or no, not better arrangement, an improved arrangements. Than that one. So let's just remain calm and wait for further instructions. So, but between now and Monday, I'm going to get back to you on the modalities for the test. This morning I was thinking that maybe I'll give you questions that you submit to my email. I give you maybe only 45 minutes to write the test, and you send to my email, where I will collate and ask your class rep to also join me in arranging the trails of maize, so that no one will have any complaint that I've submitted, I did not submit. But knowing fully that some people have issues with their network, I feel that will not be in your best interest if I was going with the test this morning. So on that note, I'm sure the class is ready for my class now.
Yes, sir.
Very well, very well.
Okay. All right.
Yes, sir. Yes, sir.
Now, so as I was saying, you have to look at the.
What is the topic again?
Please, who is asking that question? Is that Ojaku? Ojaku?
Yes, sir.
Okay, so you are the one asking me what is the topic again?
I'm now ready for the topic.
Okay. So you can see on the screen, your topic is vicarious, occupiers liability. Why am I only saying vicarious liability? So your topic is occupiers liability. Now, and I was talking about trespasser, and I was giving instances where even a lawful visitor can turn to a trespasser. And I'm glad your class had replied me with positive responses to say that these capital cases are a good example of when a lawful visitor can turn to a trespasser. Then also the case of Balogun and Alakija. So now, what aside from these cases, there are other instances where lawful visitors can turn to trespasser, and even the trespasser can also turn to lawful visitor. So, and that's why I say the fact of the case will determine whether you call someone a lawful visitor or you call someone a trespasser. Now, for example, a trespasser can turn the lawful visitor by the consent of an occupier. And this is the case where, for example, a canvasser who comes into premises uninvited. Someone who comes to your premises uninvited is a trespasser. And once you give the person that consent to remain on your land, then the person becomes a licensee. So we are going to look at the difference between licensee, invitee as we go on. So, but where business is transacted with him, there becomes an invitee. So you're going to look at the difference between invitee, licensee as explained under the principles of common law, but that dichotomy is no longer relevant anymore under the statutes. But to say, read the case of Adi and Sons W very well for further explanation on the entrance of someone, whether you're going to be a trespasser or going to be a lawful visitor. And that case is very important. Don't do with this case. It's very, very important. Then, having said that, an occupier is also free to place a restriction upon the visitor in terms of part of the premises he may lawfully visit. So where someone comes to your land as a lawful visitor, you can also place restrictions on the movement of that person in your apartment when the person is on your premises. And if he moves a step from the restriction placed, then you will not have duty towards that person anymore. Now, so another thing that you have to look at is that, because the topic is very wide, and I have to say I can just summarize by way of overview the entire topic itself. Now, again, there are categories of occupiers. There are categories of occupiers that have summarized here. Taking the cue from the Lodeni in the Wheat case, in the Wheat and the Lacon's case. So, and it says there are 4 categories, and this is one, a landlord who let out premises. Here, the landlord had parted with control of the premises, so the tenant will be the occupier. So, where you are a landlord, you have parted with occupation to a tenant. Whatever happened in the premises is no longer your business, but that of the tenants. So the tenant becomes an occupier in this case. Now, when the landlord let out part of the building, but remains other parts source as common staircase, then landlord remains as occupier of the building he has retained. And so the landlord's liability can also be several or joint with tenant. It depends on who has the control over what at the particular period of time. Then where a landowner licenses a person to use a premises, and the owner has a right to enter on the premises to do repairs, then the owner retains control and is the occupier. Deborah, James, any question or any issue? Is this still on this test? Deborah, talk now.
Good morning, sir. I'm sorry,
Yes,
my mic was unmuted.
okay.
The second point you mentioned, you said here, you said the landlord remains as occupier of the building he has retained. You mean like the particular, like in a compound, if there are like 2 buildings, you mean if he's staying in one, do you mean that particular one is staying in, or the entire compound? That's what I wanted to ask you, sir.
Okay, thanks. I said the landlord let out part of the building, but remained another part, so as the common staircase and another. Now, the way some houses are built, you may have a common stair, a common stairs, and also you may also have a common room. For example, in the hostel, you have a common room that all of you come to relax or to unwind. So, and that's why I said that the liability can be joint and can be several. So if the part that landlord retains is the part that that the injury is caused to the visitor, then the landlord will be liable only or alone. But where the part that tenant retains is the part where the injury occur, then the tenant will be liable. So, but where the injury is when the injury happens on the common stair or the summer case or staircase, then it behooves on the person who has the responsibility to take care of that part to be responsible. But ordinarily, a common staircase is the responsibility of the landlord, except there are instances, except there are understanding or some form of understanding that will make tenants to be liable for maintenance of that particular staircase. Okay, did you get the point that I explained now? Although
yes, sir. Thank you very much, sir.
Okay, although I will go into detail next week, you get it better. Now where a landowner licenses a person to use a premises, and the owner has a right to enter on the premises to do repair, the owner retains control and is the occupier. Now, you know, as we distill the difference between license, invitation, and all that, you know that someone that has a license does not have full control over the premises. So a license does not give exclusive possession to the licensee. So to that extent, the landlord may likely be the one that will be liable where injury occur, because the landlord still has access to the licensed area. But in the case of tenants, the tenant has exclusive possession over the portion in which he has been let into possession. Then lastly is on the independent contractor. So have you done a vicarious liability? Have you done vicarious liability?
No, sir.
Okay, so
Yes,
I think that would be for second semester. I could see that the class is now decreasing to 298 when I announced that then we test again. So where an independent contractor is employed to do work, is employed to do work on premises, the owner will generally retain sufficient control to be an occupier. But however, it is possible that the contractor will also be the occupiers if that contractor is an independent contractor and he has full access to the site. He has full access to the site during the time of the work or the repair. So this will depend on the amount of control which they have while the work is in progress. So if the independent contractor is giving full control, okay, over the premises, then the independent contractor will be liable in that instance. So these are some of the points that I want you to note today as preliminary to our discussion for next week. Now, and I've explained to some extent landlord and tenant situation. Now, there are situations of occupation that we also need to know. Landlord and tenants. So, the Recovery of Premises Law of various states has defined a tenant as any person occupying premises. So, therefore, primarily, a tenancy agreement vests occupation and control on tenants. So, these are the things that will determine, that will let you know, or that will give you insights or tips as to when someone can be said to be under a degree of occupation. So, in the case of landlord and tenants, in the case of landlord and tenants, the tenants will only be in exclusive possession. So, on that note, is an occupier here. So then also you have what we call multiple occupancy. So as part of what we are going to look at for next week is multiple occupancy. Now, occupation of premises may not in all instances be exclusive, and I've explained that under the second scenario that I give. So occupational control may well be shared between 2 or more persons. Which case explain all these principles very well. Now, it could be shared between tenants and landlord. So multiple occupancy. Then you have vicarious occupation, where an employer may be liable for the acts of the where an employer may be liable for the acts of the servants during the employment. So we have some apartments that are service employment or service apartments. That apartment is given to the employee because of his employment. So occupation is necessarily vicarious in situations where a master servant relationship exists. So, and this is because where the servant is in actual possession, liability rests with the master. Problems may arise as to whether there are categories of servants whose occupation can give rise to the master's liability, and that the servants can incur personal liability. So, in the case of Glasgow Corporation versus John Stone, explained this in more great detail. So, we are going to look at all these cases that are giving you as we go on. So, what again to explain before I define premises? Okay, so this is the end of the slide for today, but obviously I'm going to develop the slides and send beforehand. If I can finish before Monday, I have a lot in my table, but if I'm able to finish the slide before Monday, I will send to you. Now, we have discussed occupier, we have discussed lawful visitors, we have discussed trespass as well. Now, what do they occupy? For an occupier to be liable for a tort of occupied liability, what would he occupy? And so that takes us to the definition of premises. Now, no statutory definition of premises has been offered, but in ordinary parlance, it means houses and buildings. That is, in ordinary parlance, it means houses and buildings. Okay, so now in the case of endowment and deeds, it was defined as a term which embraces places and structures of all sorts on which persons may be invited to come. That's the definition of premises. Now, while the statutes contain no express definition, there is an implied definition with regard to things which an occupier can be said to occupy. And these are fixed or movable structures as vessels, vehicles, or aircrafts as things capable of occupation as to give rise to duty of care to visitors. So, where injury is caused to a visitor in the aircraft, the occupier of that aircraft will be liable. If it's a vehicle, the occupier of that vehicle will be liable. If it is vessel, the occupier in that vessel will be liable. So, fixed or movable structures qualify to be premises. Now, so for purpose of occupier's liability, there must be something to be occupied. And that is exactly what we call premises. Now, if you look at the purpose of Section 2 of the Rent Control Law, it defines premises to include a house or building or any part thereof, together with its grounds or other appurtenances. So when you look at tenants agreements, when you give apartment to a landlord or to a tenant, you also add an appurtenances. 3-bedroom flats at number 3 Unilag Road, Lagos. And its appurtenances. Appurtenances could mean other or other things attached to the land. So where injury is caused to a visitor in the area appurtenance to the apartment, then the occupier of that premises will be liable. So please note that as well. Now, in other words, the definition of premises can be enlarged to include even scaffolding, to include common area, less permanent structures, and so on and so forth. So it has been also suggested that since the statute does not define premises, but merely give a list of things that could be occupied, the question is whether the things that have been listed are premises are so-called. So, in other words, I'm trying to give you to let you know that the category of what will be of what will amount to premises can never be closed. So you can enlarge the definition based on things that are accidental or that are ancillary to fixed or movable structures. So as you go on, the case of Manny and Scott's will also offer us some form of succor on what premises is all about. Then Letic and Ovic. I'm sure you have seen these cases when you were reading. So vehicles and aircraft, of course, are be held to be things that can be occupied. Okay. Then again, Lagos State's Tort Reform Law or Lagos State Law Reform Tort Law of 2013 has also defined or has also given a tip on what premises to include, and specifically said include fixed and movable structures. Fixed and movable structure. So part of that section 9(2) of Lagos State Law Reform Tort Law. I would advise to get this law because there's some discussion that we are going to make under this particular law. So you can Google the law online, or you can download it online. You can section 9(2) Lagos State Law Reform Tort Law of 2013. Okay, so and if you read your accordingly Analytical also, you will see the equivalent section in that law. I think section 7 of them, section 7 of that law, okay, defines premises to include not only land and buildings, but also any fixed or movable structure, including any vessel, vehicle, or aircraft. So that definition is totally different from what we have in 2013 law. So some mistake that your senior made last year, and that's why I just advise that Kony Analytical is a good law textbook, but at best it can only give you foundational knowledge. You need to read wide, and not to rely on Kony Analytical. Kony Analytical only has limited discussion on this area, and that's where most of the sections cited in that law, in that textbook, are from the old tort reform law, law reform tort laws of Lagos State. So I'm sure you'll not be making mistake by coming out with sections that are no longer relevant. Okay, so I think that was the mistake I saw in the answer that most of them did. The part they answered last year, I was seeing provision of section 7, section 6 of Lagos State Law Reform Tort Law, and that was the law. I think that was 1961 law, that they were quoting or they were citing, and that's what you are going to see in the accordingly analytical. Okay, so read the 2013 law, and I'm sure you have the equivalent sections. Then I also advise that you go through the provision of section 12 and 19 that talk about savings provisions of the tort law 2013. So for further interrogation. So by and large, premises are land, buildings, and any fixed or movable structure, including any vehicle or aircraft. Okay, so see section 1 to 3 of the English Occupiers Liability Act of 1957, manning and Scots, LETIC, and the OVIC are all displayed on your screen. So I think I've exhausted who is an occupier, who is a level visitor, what categories of occupiers, then situations of occupation, and what have I left out so far? Okay, I don't think I've left out anything so far than to, because we still have time, we have like 20 minutes to go, down to just also to mention that when you talk of lawful visitors, the category of persons that were among to lawful visitors are explained under the common law category. And at common law, the distinction is made between invitees, licensees, and contractual visitors. Now, at common law, invitees was defined to be the person entering the premises and whose presence afford the occupiers material benefits. Don't forget I said that this distinction is no longer relevant under the statutes. But to lay your foundation very well, you may begin answering questions like this by giving us the background under the common law. So now, at the common law, an invitee is the person entering the premises and whose presence afford the occupiers material benefits. So, licensees is the person entering premises with the occupiers authority without affording him any material benefits. So, licensee is taking the body, is giving the body to landlord. But invitee will be giving benefits to the landlord. So then you have what we call contractual visitors. Visitors are persons entering person to contract with occupier. So you have contract to enter the premises. Okay, and a good example of this contractual obligation or with the occupier is that where someone is asked to come and work on your land, for example, plumbers and others. So they are there based on they are there as contractual visitors. Okay, so and the basic aim of the English Occupiers Liability Act of 1957 was to dispose of the highly artificial distinction between lawful visitors and also trespassers, lawful visitors and the trespassers. So, and I've discussed who is a lawful visitor, persons who at common law be treated as an occupier, and his invitees and licensees. These are lawful visitors under common law. But no decision is made by the statute between licensee and invitees. So therefore, both of them are all duty of the common duty of care. So, and in this direction, the material interest of the occupier in the visitation is no longer the yardstick for determining the duty he owes to his visitors. So whether you're a licensee, whether you're an invitee, you have the occupier own duty of care to you, not to put you in a perilous state, to ensure that his property is safe from hazard. So, and of course, I've already discussed those that are visitor as of rights. Okay, those that perform statutory duties. Then, what again have I left out? By way of introduction. So, class, any question before we call it a day? Any question?
Sir, I have it's more like a need for clarification. You were talking about just now, sir, you were talking about how common law divided the how the 1970 and 1957 statutes distinguish between lawful visitors and trespassers. And you said that lawful visitors are divided into licensees and some others. I'm sorry, sir, I didn't get that.
No, don't get it wrong. What I'm saying in essence is that I said that before the 1957 Act, okay, that is our basis, the basis of our discussion. Occupiers Liability Act, when I started, I said before the parliaments in England came out with the Occupiers Liability Act of 1957. Okay, so there was common law of occupiers liability. So, and I said that at common law, that decisions were made between visitors. Okay, so that visitors are categorized under invitee, licensee, then contractual visitor. So, and the purpose of that distinction is to show whether the occupier will benefit from each of them. And I said for invitee is the person entering the premises and whose presence afford for the occupier material benefits. So material benefits is relative, but however, his presence benefits the occupier. So to that extent, the occupier must ensure that he does not expose him to occupational hazard. Now, 2, licensee. Now, and I say licensee are those entry premises with the occupier's authority without affording him any material benefits. And I said this to some extent brings burden on the occupier. Now, when you give someone license may come with giving someone a place without collecting a dime from the person, because you also have access to the person. You can also use the bill at any time. So that's like a body. So that's why the person is called a licensee. And the person does not have exclusive possession. So you only give the person a license. And I said for contractual visitors, these are person entry pursuant to contract with occupier. So and I give example of plumber and those artisans working in working on your terms of contract. I said the basic aim of English Occupiers Liability Act was to dispose of that distinctions. So it is that act that might say made that distinctions inconsequential. Okay, so between lawful visitors and even trespassers. Now, by next week, when we discuss trespass, because I'm going to discuss trespassers fully next week, and that will take us to what we call common humanity. So why the 1957 Act, as we're going to see later, only talk about lawful visitors with permission. And I mentioned before that it is the 1984. If you follow my discussion from the beginning, it's the 1984 Act of England that talk about visitors without permission. And I said visitors without permission are trespassers. So, but even at that, whether someone has permission to enter your land or not, it has to do with degree. And the law also stipulate certain duty that Who is that person now? Who is that person now? See, these are examinable area, and I will not speak on that. I will not speak on that. So, why you continue to make your noise? Let me just say this, that the artificial distinction between licensee, invitee, and contractual visitors is now inconsequential by virtue of the English Liability Corporate Liability Act of 1957. So it modified common law principles of occupiers liability. That was the point I'm making. And the discussion as to the difference between lawful visitors and trespassers are still there. Because 57 Act protects lawful visitors with permission. Trespassers are those without permission. And so, today I only give an overview. So, by next week, we are going to look at in what instances. I've even given some of them today. And I said that lawful visitors can talk to trespassers can also turn to lawful visitors. So, but by next week, we are going to discuss properly all this background I've given you. So that the class will not be totally or partially did not today. That was why I said, let me come to class and give you the background to the discussion for next week. Okay, so on that note, I want to say before I wake up further question that is there are you when do you want your test? Do you want it next week or do you want it upper week? Before I give 5 minutes for questions.
Upper week, sir.
Upper week, sir.
Sorry, can we know the modalities of the test first?
Don't worry about modality for now.
Can we do a poll and get back to you, sir?
No, don't do a poll because I don't want I don't want this open secret to go outside this class.
Sir, upper week, sir. Upper week, sir.
Upper week. Upper week.
Okay, no, don't show upper week. We don't do upper week in our lecture because it's Monday, Wednesday, so we can't show upper week. So maybe upper week is saying Wednesday next week. That's the meaning. So I can only accommodate that for next week Wednesday, hopefully. So prepare towards next week Wednesday. Why I interact with my superior, or okay, listen, my senior on the modalities. Okay, but like I can show you, you'll be happy with any modalities that I want to use. Okay.
Yes, sir.
Okay.
All right. Okay. Any question, Vai? Any question? Any question?
Sir.
Okay. In the absence of further questions,
I just want to thank you for your time, sir.
Okay. Okay. Yes, I'm with you.
Yeah, when you were speaking, you said a person with an implied permission. Sorry, I'm coming. Sure.
I can't hear you well.
Coming.
Before, I have other Oluwadamilare, you have a question?
Yes, sir. I just wanted to clarify something you said. You said by virtue of the English Occupiers Liability Act of 1957, the differences between, and then you mentioned, I think, licensee and something else. I did not really get that part, sir.
I'm saying that the dichotomy between licensee, contractual visitor, has been phased out. Maybe that is that word. So there's no decision between the three anymore. Between whether you're a licensee or you are you're a visitor or you are an invitee. Okay, so it's not one and the same. That's what I'm saying. Is
Okay,
that
sir.
clear now?
Thank you, sir.
Okay.
Yes, sir, it is, sir.
Okay.
Yeah, hello, sir. Hello, sir. Hello, sir. Oh, grabbing my mic.
Go ahead now.
Okay. Oh, okay. You said a trespasser may turn to a lawful visitor, but
Yes.
where one gives like consent,
Yes.
the trespasser becomes what? A lawful visitor, or did you make use of any time, any other time aside?
It becomes
that?
it becomes a lawful visitor.
Okay.
Yes. You know that the vacant liability, our occupied liability is a very interesting course. A very interesting topic. Have you taken time to read before you come to class? Have you taken time to read before you come to class at all? I don't think so. You were busy for test. You were busy for test.
Yes, sir.
Okay. And no problem. So I will start next. We start next week Monday. God willing. Okay. On that note, I wish you enjoy the rest of the day with Fusion. Bye.
Thank you, sir.
Thank you, sir.